Hello, everybody, and welcome back to SEC Roundup. My name is Nick Morgan. I'm the founder and chair of Investor Choice Advocates Network, ICAN, and the co-host with Tom Zucchero, my long-suffering colleague. Tom, thanks for joining this episode of SEC Roundup.
Oh, my pleasure to be here.
And our special guests today are Manouch Moshayedi and Nelson Obus, two people who, for anyone who follows SEC litigation, SEC enforcement trends, will know each of them famously defeated the SEC in trial in front of a federal court jury. Manouch, thank you so much for joining.
Thank you.
And Nelson, thank you so much for joining.
Glad to be here. Yep.
So obviously, or at least it's obvious to all of us, the reason we're getting together is because the SEC had a tough week in the Supreme Court last week, to put it mildly. Two blockbuster cases came out, maybe three, impacting the SEC. The one we're going to talk about today is a case called SEC versus Jarkesy. Mr. Jarkesy prevailed in the Supreme Court, which held that he, like other people who are facing SEC enforcement actions involving fraud claims and pursuit of civil penalties, is entitled to be in front of a federal court jury, which comes as a surprise to the SEC, which has for decades indicated the opposite position. But the Jarkesy decision in the Supreme Court is really the end of the story. And maybe it's the beginning of a new story, but it's the end of a story that started with Mr. Moshayedi and Mr. Obus and another fellow, Mark Cuban. And this takes us back to 2013, 2014, which is why we've gathered here today to provide some context and a little bit of history on the Jarkesy decision. So, as many of you will recall, there was a statute passed that became effective in 2010 called Dodd-Frank. Dodd-Frank expanded the SEC's ability to use administrative proceedings and bring different kinds of cases and seek different kinds of penalties in front of their own administrative law judges who are employees of the SEC. And when that happens, when the SEC proceeds in an administrative proceeding, the respondent or defendant is denied the right to present its defense to a jury. So that happened in 2010. Flash forward to 2014, there was, as I alluded to earlier, a string of SEC losses in federal court in front of juries, starting with Mark Cuban's trial in late 2013, and then followed in quick succession by Manouch's trial with Tom and Nelson Obus's trial in 2013. There is a Reuters news article right after those two losses. We cited this article in our amicus brief, and thanks to Mr. Moshayedi and Mr. Obus for joining that brief, along with Mark Cuban, Phil Goldstein, and Elon Musk. But the Reuters news article in 2014 interviewed the then director of enforcement at the SEC and asked the director of enforcement, you keep losing in federal court. Like, you have this new power from Dodd-Frank. When are you going to start using it? And the director of enforcement said, yes, you're right. We are going to start bringing these cases more often in our administrative proceedings. And by the way, and this is what I thought was quite a chilling statement by the director of enforcement, recently, all we have to do is threaten to bring the case in an administrative proceeding and people settle. In other words, all you have to do is threaten that you're going to subject people to an unfair process, and lo and behold, they don't want to go through that process. So with that sort of long wind up, Tom, let me start with you. Obviously, you and I were trial counsel at the SEC. We have defended people in trial against the SEC, and you had the honor of representing Mr. Moshayedi in a jury trial, the one I just alluded to. Tell me a little bit about why, from a lawyer's perspective, we'll get the client's perspective, and why, from a lawyer's perspective, is it important to have at least the opportunity to present a defense in front of a federal court jury?
Yeah, thank you, Nick. I mean, the Supreme Court went a long way to leveling the playing field between the SEC and the defense. Before, when the SEC could take these cases to an administrative law judge who worked for the commission's win-loss record was, similar to that of the Harlem Globetrotters. It just wasn't fair. you had no or very limited discovery. You had to accept the SEC's administrative record with limited ability to create, to gather your own evidence. You had an ALJ who worked for the commission deciding the case as opposed to an Article III judge. And perhaps most importantly, you didn't have a jury, which I know in Manouch's case, since I was in the courtroom representing him, the jury made a huge difference. I'm sure Nelson would say the same thing. So, as Justice Roberts said in his opinion, the dissent, those justices who dissented would have, the SEC serve as prosecutor, judge, and jury. And that is facially unfair. And at least for the type of case the Supreme Court addressed, a case seeking civil money penalties, that now needs to be brought in federal court. The other decision that came out last week that really bears on this, and it's something that was argued in Manouch's trial and probably, I think, in Nelson's as well, and that is they finally struck down Chevron deference. And what Chevron deference is, what that doctrine said was, when the SEC or a government agency adopts a rule within its subject matter expertise, the court should defer to that rule. Supreme Court said no more. And this was critical for us, and I think for Nelson as well, because in our trial, the SEC had a rule which defined what the SEC needed to prove insider trading. And at least in the Ninth Circuit, where our trial was, Manouch's trial, that was contrary to Ninth Circuit law. And we argued that the rule was, because it was contrary to the law, it shouldn't be followed. And the court said, well, I have to give it Chevron deference. That doctrine is gone. And I think with it, the SEC's rule on what it needs to prove insider trading is gone. So with that wind up, let's talk about the trials and the advantages of having a judge, an independent judge, having a jury, and having discovery. Manouch, I remember the trial. It was 3 weeks long, very emotional. Obviously, we were all very gratified by the verdict in your favor. Tell us from your perspective what it was like and how important it was to you to have a jury and a judge decide your case.
Yeah, it was a very, very difficult time for me, obviously. It had gone on, the lawsuit had gone on for almost 5 years. It destroyed our company, made 1,000 people unemployed, and the SEC lawyers and all the functionaries seemed to be unremorseful, completely arrogant, stupefying stupid, and people who just they're not good for this country or for anywhere else. I mean, I would not let these guys carry a pail of water for me. They were that bad. They were so bad that they actually fed, I don't know if you remember or not, fed 2 analysts a bunch of lies to come and tell on the stand. And not only it was funny, the judge recognized it, all of the jurors recognized it, and made the SEC look like a bunch of fools. All along, I mean, with everybody that we had as lawyers who had contact with the SEC and the SEC higher-ups, for 5 years we pleaded for them to go and argue our case in front of a grown-up. And they denied that access to us at every single level. And the court case kept on going one level higher, and one level higher without any discussions, based on an idiotic brief that a simple analyst had written 5 years before we ended up in a court. It cost our company tons of money, lots of jobs, and destroyed our company. They completely did this whole thing with bad faith. And I'm sure had we gone into the SEC for a judgment, it would have just followed up with the same bad faith on the part of the SEC and its functionaries. So our last chance and the last thing that straw that we were pulling was the jury. And fortunately, our jurors immediately, within a couple of days, recognized that the SEC's case was just complete nonsense. They were a bunch of liars, and they were lying through their teeth to a point that every single time they brought up the case, the jurors would just roll their eyes. They pulled over 1 million emails from us. And out of all of those emails, as you recall, they highlighted one single sentence on all of those emails that I'd written to one of our customers, which said, what does it take to get this purchase order? Now, this is a simple thing that every single person goes through every single day. You get a bargain, you go shopping. You don't get a bargain, you don't go shopping. And it's just a very simple sales technique. And the SEC failed to recognize that, as if they're from a different planet altogether and don't know when after 4th of July sale comes or after Christmas sale comes or have never gone shopping before. It was stupefying. It was just mind-boggling that they were asking me for not only all the money that we had done a secondary on, but 3 times that money. They wanted to bar me from any work afterwards. Basically, they wanted to destroy everything that I'd built over the past 30 years based on a say-so of a simple analyst who had misjudged his interview with me. And that can't go. That can't go on where there are no checks and balances, going on and on and on, costing companies jobs and money and the businesses based on a say-so. Some higher up, someone with better intelligence has to finally come in and judge the situation. And I'm sure had we gone to an inside SEC court, we would have been completely judged right from the beginning, guilty, and all of the things that SEC was asking would have come true.
Yeah, you
I don't
raised
want
something interesting. Sorry, Nick. Which goes to a jury trial. Their first witness, SEC's first witness, was an analyst from Chicago who clearly did not want to be at the trial. And he testified on direct, and then the judge told me he had to stay over for the next day. And that analyst was so angry that his anger at staying over was evident to the jury, who, of course, was stuck coming to the courtroom every day for 3 weeks, and evident to the judge. And then the judge said something to him, and he waved his hand dismissively to the judge. And the judge was furious with him and dressed him down in the courtroom. And you could not have had a worse start for a trial in front of a jury. You remember that, right, Manouch? And the jurors were all laughing and rolling their eyes. And, that without a jury, we would have lost the impact on an ALJ.
Well, I think that's a
Right.
really
I mean,
important
remember,
point. Sorry, go ahead, Manish.
so that same analyst, the judge asked him to read one of his reports, which was a glowing report about our company that he had written just a few months before the court case started or the lawsuit started. And he said, I can't read it because I don't have my glasses. And the judge says, okay, we're going to go into recess until you go get your glasses from your hotel. I mean, it became a complete joke that the guy who had written a report was not willing to read his own report and was trying to make some sort of excuse why he couldn't read his report. Anyways, he ended up reading his report without his glasses, and it basically, and also a second analyst that they brought in that was just a liar, the beginning to the end, and it was so obvious, everybody recognized it.
Well, I think the importance of the jury, I mean, you mentioned, Nelson, that the jury could appreciate something that happens to everybody every day. It's that common sense Let's just not get wound up in things that don't matter. Nelson, I want to make sure we have time to hear from you as well, because your jury trial, of course, came out in your favor after a very long fight. What was it in your case about having access to a jury in particular that you found particularly important?
Well, I think first and foremost, a jury of your peers who you've not met before is an even playing field. We used to, we've been critical of the administrative law justice system from the get-go, because as we used to say, the administrative law judges and members of enforcement and litigation within the SEC have lunch together. And there's actually some truth in that. And, if you're that close together and you're both in the same profession, it's so easy, to form as objective as you want to be. It's very easy not to develop a bias over a period of time. There were a series of things that happened in the trial, which showed the ruthless and unmitigated lack of honesty and even-handedness on the part of the litigation team and to some degree the enforcement team. So there's no question that in our minds that having an entity like the ALJs having contact on a regular basis with members of the enforcement and litigation side of the SEC was not going to. They were going to be influenced by the ethics of the SEC team, especially since they were of the same profession. And just to give you a sense, when we were brought down to Washington initially for to be deposed, it was the Friday before Labor Day in 2002, and they tried to keep us overnight. That after saying that they wouldn't. Then when they made it clear that they were going to bring charges against us almost 5 years later, which was the statute of limitation, they said that it would be done very lightly, and then they went to every newspaper in the country. One thing I found out during the trial, which was kind of interesting, is that enforcement gets paid on the basis of how many cases they bring, and litigation doesn't get to opine on the chances of winning. I guess they were so sure of themselves. We tried to go through FOIA, to get a better view of that, but we were blocked on every account, at which point we felt our efforts would be better used to attack the ALJ system. One of the really interesting things was that the judge warned the SEC that they could not, for any reason, find us liable for being successful as a money manager. And the SEC went ahead in their concluding remarks and tried to hold us successful, hold us accountable for being successful. They actually said that if you allow these people to go free, that will impact your retirement money. I mean, it was crazy. They got reprehended by the by the SEC. I'm sorry, by the Judge Daniels at the time, which I thought was pretty interesting. The other thing that happened, their key witness, a gentleman named Russell, who claimed that he represented the actual buyer of the company, which I was accused of loading up in prior to the announcement of the takeover. He actually talked to the SEC and said that I had told him that I had bought shares based on that information prior to the announcement. Well, of course, my lawyer said if that's what he did, he must have been the dumbest hedge fund manager in the world. But it was an out-and-out lie. And under cross-examination, this individual actually, he was caught between a rock and a hard place, because if he lied, if he brought back, if he retracted his testimony, he would have been lying in front of the SEC. So he actually said that he forgot about the whole dialogue, which of course had never happened. And then the judge then the SEC tried to have him deemed to be a hostile witness. It was really quite a defining event in the trial. But getting back to the jury of your peers, the whole thing with the SEC was to try to paint me as an unethical and money-grabbing individual who was in a sordid business to begin with, the hedge fund business. We tried to make it clear that we're a small entrepreneurial group of people falling into the small business category.
Well, I think we'll leave it there. I thank you, Manouch, Nelson, for relaying the stories of your trials. Thank you, Tom, as always, for your time. I mean, it is incredible that a group of ordinary people can cut through things in a way that just brings common sense to proceedings. And thank goodness the Supreme Court has guaranteed the right to access to a jury in certain SEC proceedings. So we'll leave it there. Thank you all. And for anyone else, if you want to hear more about ICAN, go to icanlaw.org. Otherwise, we'll see you on the next SEC Roundup. Thanks very much.
Thank you.
Thank you.
Thank you.
Thank you.